Good
afternoon. Welcome to this webinar on Resolution Plan, the Key for Success in IBC. And we have with us today the Chairman, Committee on Insolvency and Bankruptcy Code, CA Gyan Chandra Mishra ji. I would request, sir, to please begin with your opening remarks. Over to you, sir.
So thank you, Rita Madam, very respected Secretary of the Committee. Good afternoon, one and all, respected speaker of today's program, CA Vrind Jain ji, and of course, very young and vibrant moderator of today's program, CAS Badri Narayan ji. Friends, we all know that today's webinar is on a very important topic, that is resolution plan, the key for success in IBC. So IBC came about 7 years back, and since then it's evolving. We all know that resolution plan is one of the most important part of the document which we submit before the adjudicating authority for resolution of the various aspects of the corporate debtors. The resolution of various aspects covers not only one part, that is realization, the other part, how to pay, what to pay, and how the balance to be taken care of by the other stakeholders. Friends, we all know that Honorable Adjudicating Authority has all the powers to seek some modification in the resolution plan, to get it vet by various stakeholders, to sort out the various issues which are pending before the Honorable Adjudicating Authority, and of course, most importantly, to sort out the disputes arising out of the resolution plan, which the various stakeholders put before the Adjudicating Authority or before the other honorable courts. Friends, resolution plan is very important, a plan in which the entire ecosystem of the corporate debtors is being depicted, and that is being taken care for the furtherance of the corporate debtors as going concern. So for these two wonderful personalities, you can see on the screen one very much young and energetic, who will be moderating, Badri Narayan ji, and the other one, Vrind Jain ji, of course, full of experience, learning, and most importantly, had a good knowledge base of the IBC laws. Friends, I once again welcome you all in this webinar. The committee is always dedicated for the dissemination of knowledge, and not only this, for the betterment of the professional life of the insolvency professionals. I will not take much time. One important announcement that I would like to tell you, that the IBC committee is going to host 2 days International Convention of Insolvency Professionals in Singapore on 4th and 5th of August 2023. This is one of unique opportunity for the professionals, because a lot of opportunity to network, to learn, and of course, to have a great fun in Singapore. This all in a wonderful combo being provided to all the insolvency professionals. I'll request you all to kindly get registered. We are going to open the registration within 2 or 3 days. Get registered, enjoy, network, and learn for the betterment of the profession, for betterment of ourselves. By these words, I welcome one and all, and over to Rita Madam to kindly tell the participants a bit about the committee, what the committee is doing for the members, and of course a brief introduction about the gentlemen on the screen, I mean Jain sir and Narayan. So thank you one and all. And friends, since I have one meeting, I would like to take your permission, and I'm sure that we are meeting in Singapore with full enthusiasm to enjoy and learn. Thank you.
Thank you, Chairman sir, for your opening remarks and setting the tone for today's topic about the resolution plan, its important aspects, how it is important under IBC. And Chairman sir also informed all of us about a big announcement which he made today about the international convention which the Committee on Insolvency and Bankruptcy Code is organizing at Singapore on 4th and 5th August. The details of the same will be available very soon, and the registrations will also begin very soon. And about the committee is taking various knowledge dissemination exercise. Like this year, one important initiative we have taken that we are going to bring knowledge corner on IBC every month. It will have news updates and various case laws update on a monthly basis on IBC. And there is also a small corner on quiz, which we are going to include in this knowledge corner. So the members can participate and they may even win prizes for that. And we also conduct webinars like this on important topics, emerging topics, developments under IBC. And we also have a case series on successful resolution case under IBC, which we conduct on a regular basis. And most importantly, besides this kind of programs, we are also doing a lot of programs in physical mode this year for preparation of exam purpose, for limited insolvency exam preparation purpose. We conduct programs in the branches and in the regional level. And we also have online certificate course on IBC for the benefit of the members. Now I will take the opportunity to briefly introduce our speaker, Krishan Jainji, and our moderator, Badri Naranji, to our members who have joined today in this live webinar. CA Krishan Vrind Jain, he is a chartered accountant, a fellow member of ICI. He is in practice for over 30 years, having experience of project financing, commercial litigation, taxation, and transfer pricing. He is an associate member of the Institute of Cost and Works Accountants of India. He is specialized in international taxation, technology-oriented firms, iron and steel, pharmaceuticals, chemical, bulk drugs, packaging and printing units, and engineering and building construction materials. He has provided trainings for courses of resolution professionals. He's a trainer with Indian Institute of Corporate Affairs, Ministry of Corporate Affairs for certificate course in insolvency and bankruptcy laws and procedure. He has delivered various lectures on insolvency and bankruptcy laws and procedure at various regional and national forums of the Institute as well as for IBBI program. He's also a certified forensic auditor from ICI. Welcome to you, Krishnan sir. Now I'd like to introduce CAS Badri Narayanan, who is going to moderate the session today. He's a chartered accountant, a qualified company secretary and lawyer, working in the insolvency restructuring space since 6 years. He has handled multiple CIRP and liquidation assignments, including preparation of resolution plan. He has published in diverse reputed journals of like ICI, ICSI, International Corporate Rescue on subject of insolvency. With this, I would now welcome to Badriji also. I would request Badriji to please begin with your initial remarks. Then you may hand over the session to Krishna Venji for his presentation on the subject. Over to you, Badriji.
Thank you, ma'am. Thank you. First of all, at the outset, I thank the CIBC committee. They've been doing wonderful work and a lot of good webinars, good subjects, interesting subjects, which people don't get into are being organized by CIBC. It's a great effort. So thanks to the entire team. Thanks to the chairperson. Thanks to Rita ma'am for doing this. And I feel humbled to be in the presence of Jain sir. I can't explain in words the experience he has. And I'm looking forward to this session. A lot of things to learn from his experience. And experience teaches us a lot of things which you can't find in black and white in the law. I mean, law is made out of common sense and common sense is gained out of experience. So we look forward to Jain sir's expert insight on the resolution plan aspect. And I'll try to keep it very short. So the preamble of our IBC code says it is for reorganization and resolution of insolvency. So the prime objective is resolution. So even in a CRP process, it's a resolution. Even in a liquidation process, it's first of all, you try to resolve by going concern. You don't try to liquidate as a piecemeal basis. So the prime object always has been resolution. Only as a last resort, do you go for a piecemeal basis liquidation. Even if you look at the section 5 subsection 26 of the code, which defines the resolution plan, it says a plan proposed by a resolution applicant to resolve a corporate data as a going concern. So the entire emphasis is on a going concern. It's a very good area to practice as well for chartered accountants, for our members, for our fraternity, because you have a lot of strategizing to be done here. Resolution plan, we can say, is the core document, which is the revival document for the entity, which is going to look at the problems which are there, how the stress came in the first place, how the resolution applicant is going to address the stress, and then how it's going to implement the stress. It gives a future timeline also. It's not just I picked up the corporate data and I'm running it. It's also about how I'm going to run it in the future, how the employees are going to be treated, if I'm going to retain the employees or not, how are other stakeholders' interest balanced. So we can call it a core document in the entire resolution process. It is in fact the life of the CRP process. Even when you go a going concern liquidation, there also you have a very similar documentation like resolution plan, like an arrangement or scheme. So it's the core life of the entire process. It's going to be a very interesting session. A lot of practical aspects, different challenges. I will look forward to hearing from Mr. Jain sir. And I think we all as members have can make use of this opportunity, this knowledge session, to gain from this. And this also throws up a lot of professional opportunities. So we have chartered accountants who are doing brilliantly on resolution plan preparation and strategizing, even sitting on the COC side, advising the COC how to evaluate the resolution plan, how to do the NPV analysis, how their interest is taken care, and as advisors to the RP. So all the areas chartered accountants can be a value addition in this entire process. So I hand over the platform to Jain sir. I'm going to be there throughout the session. I'm going to be receptive. I'm going to learn everything, sir. I'm not going to leave 1 second of this session. Thanks a lot for giving your time, sir. Over to you, sir.
Thank you, Narayan sir, and thank you, Rita ma'am. And once again, I thank our chairman, Shri Gyan Chandra Mishra ji, for setting the tone, and Narayan sir giving just a brief insight into the resolution plan. And that's really great. And I'll be just sharing my screen now for the slide share. Yeah. So basically today we are going to have this topic of resolution plan, that is the key to success in IBC. And my take is the whole of the code is basically dependent upon how a resolution happens into a sick unit. So this is just akin to be a doctor, means being a chartered accountant, being a finance professional. I always used to wonder that our profession is always, as a chartered accountant, is like that we are doing the postmortem job, that we are doing the auditing, whatsoever people has done. We are just checking that and looking into the working of the company, what they did wrong and what wrong things we have to report. So excitement was altogether missing. Now, once this IBC was introduced and a new breed of a profession came into being, that is IRP, RP or liquidator, as certified by IBBI, they came into being. And I had the feeling once I joined this profession that from a doctor of a postmortem job, I have been promoted to a doctor where I have the capacity to revive a patient, where the patient is almost on the deathbed or onto the deathbed. And as a professional, I have been given responsibility to revive it back. So resolution plan is basically that support system which revives a ailing company, a sick company back to its feet. So it is such a satisfying experience once you revive a company and see the smile on the faces of a lot of people who are around in that particular arena or in that particular ecosystem. So preamble of the code, as Narayanan sir was discussing, I'll do it in little detail. So basically IBC was an act to consolidate and amend laws relating to the reorganization of insolvency resolution of corporate person, partnership firm, and individuals. So incidentally, right now, the CRP process or the all process is only on for corporate persons and LLPs, not for the partnership firm and individual that is yet to be notified. And the main objective is it is to be done in a time-bound manner for maximization of value of assets of such persons, means stakeholders, to promote the entrepreneurship, availability of credit, and balance the interest of all stakeholders. So basic aim IBC came into being with was, once a company is into ailing position, the company is getting sick, you immediately get into IBC, means you immediately rush to the emergency hall of a hospital. So IBC is a emergency department in company restoration. So once company gets into IBC, it should be immediately taken care of. The ailing part should be deleted from that company and it should be revived so that all the ecosystem attached to that company, because a lot of people are dependent upon a big company. Lot of ancillaries are there, lot of suppliers are there, lot of workers or employees are working. Then whole of the distribution system, marketing system, and everything, customers are dependent on that company. So whole of the ecosystem starts collapsing once one mistake happens in the CD, one financial bungling happens into a CD, or one wrong technical decision is taken into that CD. So that company can be very beautifully revived back through IBC. No other act as present on date has that capacity which IBC possesses, because there is a clean slate theory under IBC, which gives the company as a clean state to the next promoters who are going to handle that company. Means a running business with all its paraphernalia, without any liability or litigation, is being handed over under IBC calmly to the new promoters or to the new management to run it effectively. That is the beauty of this code. That is the beauty of this act, which is unmatched under any law as on date it is present. So you can alter the order of priority of payment, and government itself took a decision to take a back seat. So what it used to be in the earlier acts, the government dues had the priority, but now under IBC, government took a conscious decision that all other stakeholders should take their stake and we will take it on the later on basis. So that is a very big, bold step taken by Government of India. But right now, I'll be discussing one or two judgments which are now becoming impedient into this process, which is going against the basic object of the IBC, and how I think so Parliament is going to react to that, whether they are going to amend that act or whether Supreme Court of India is going to take a call and review that particular judgments and do some relief in this particular area where the priority of payment of government dues were taken little bit back, but because of those judgments, it has again come up due to operation of those judgments. And other object was to establish Insolvency Bankruptcy Board of India. That has been established and it is working beautifully. That is controlling the profession like anything. Now the resolution, yeah.
Krishna sir, put it in big screen, sir.
Okay.
Yeah.
Just a moment. Is it?
Yes, sir. Yes, sir.
Is
Now
it?
it's yes. Thank you, sir.
Thank you. So, resolution plan. So, resolution plan under section 5, subsection 26 of IBC means plan proposed by resolution applicant for insolvency resolution of a CD as a going concern in accordance with part 2. So the most important thing in this definition to be read is that any person can give the resolution plan to the insolvency professional but it has to be for the company as a going concern. Means resolution plan can't be given for the company to be closed. So the resolution plan must say the company will work as a going concern. And who could be the resolution applicant? A person who individually or jointly with any other person submits a resolution plan to the RP pursuant to the invitation made under section 25 subsection 2H clause. So any person can give the resolution plan, whether individually, whether jointly with a company or a partnership. So all persons are eligible to give the resolution plan once it is called for under section 25 2H, subject to the provisions of section 29A, which are the disqualification provisions being made inbuilt now after introduction of IBC. Once there was a lot of commotion that the promoters are getting into IBC to grab back their companies at a much discounted prices. So for our resolution plan, the process which runs in a simple words is on your screens. Once a company gets into CRP, we advertise to call for the claims. We receive the claims. We make committee of creditors out of that. So committee of creditor under IBC are the now true stakeholders who run the company. The company's running is taken over from the promoters, and that comes into the hands of RP. RP runs that company on the directions and insistence of the COC members. So once that COC and everything is complete, RP starts studying the CD in detail. There, in the first step, we finalize the investment teaser. We study the business model and we prepare information memorandum about the company. Then expression of interest in Form G is issued with the permission of COC, where the Form G basically calls for people to express their interest to be the resolution applicant for the ailing CD. Once people are there, we execute NDA, confidentiality undertaking, with the prospective resolution applicants, and we circulate the investor teaser. We set up a VDR, virtual data room, and we circulate the information memorandum, business model, and other details to interested resolution applicants through VDR. So RP makes a process memorandum and inform the resolution applicant along with the evaluation matrix. So all this process memorandum and evaluation matrix are basically prepared by RP and passed by COC in a COC meeting, where they decide what basic conditions they want, what kind of a resolution applicant should be, how much net worth he should have, what kind of experience he should possess, and what kind of offer, how it will be evaluated. That everything is given in the evaluation matrix. And process memorandum defines how the process of resolution plan acceptance, opening of the resolution plan, negotiation with the various resolution applicants will be done, and how it will pass through and happen to be executed. Now, the prospective applicant submits non-binding term sheet. Once they submit a non-binding term sheet, then these prospective resolution applicants conduct the due diligence, and RP facilitates them with the plant visits, facility visits, or in-depth information what they want about the working of that particular company. After that, shortlisting of parties based upon offers is made by the resolution applicants, is done by the RP. He does all the pre-scrutinies of the resolution plans, whether they are in accordance with law or not. All the resolution applicant are compliant with section 29A or not. So everything is shortlisted, and a due diligence note by the RP is prepared on each and every prospective resolution applicant. Then we share the additional details and clarifications as required by the applicant, whatsoever they want. Then ultimately, they submit a binding resolution plan by the shortlisted investors. Once those plans are received, those plans are scrutinized, all those plans are put to COC for ultimate scrutiny and negotiation of the COC. So this is a small process which is right now on your screens, how we run a resolution plan process. Now, you might be the resolution applicant, you might be part of CD, you might be part of the COC members, or you might be part of the RP team. There are many roles where the chartered accountant can fit into this whole process. Now I'll discuss how we draw a resolution plan, how the resolution plan is basically made. So a resolution plan details the steps that have to be taken should a CD run into a trouble. So what are the objectives? And basic three objectives are to be kept in mind once you are appointed as a consultant for any prospective resolution applicant, or if you are studying a resolution plan, even then you have to keep these objectives in your mind. First, to gain an understanding of how the CD operates, what is the critical functions of that CD are. Now, to identify any obstacles to the CD's resolvability and remove those. And third, the foremost and the most important part is to be prepared for the resolution. Now, why I'm saying to be prepared for the resolution? The maximum time, what I have experienced when every resolution applicant who is soever is coming to me is basically coming to buy an asset. And resolution plan is not buying a company, not buying an asset. Resolution plan, the person should be mentally prepared to resolve a company which is ailing. There is a difference in buying a company, buying an asset, and there is a difference in be prepared for resolution. Because normally people come to me that, sir, this XYZ company is undergoing under IBC, under CIRP, the assets are so good. The asset value should be around 1,000 crore of rupees. And I think so under IBC, I can buy that for 500 crore of rupees. So that is a very good bargain. Kindly prepare a resolution plan for me so that I can have this company. So that is the first and foremost mistake a resolution applicant can make. So as a consultant, you should first prepare that resolution applicant, what the things are, how the things will work under a resolution plan, and how he should be prepared for the resolution. I will run you through small 6-step theory, how a resolution happens around the world, not only in India, around the world. So these 6 steps are: step 1, you do the strategic corporate analysis. Then after doing the complete corporate analysis, you prepare a resolution strategy. After preparing a resolution strategy, then you see how the financial and operational continuity will happen in that particular subject. Then in step 4, you have to be pre-decided how information and communication of plan will happen, because change of management is the most difficult part in change of a company. So any company can stand or be destroyed in the process of change in management. And 5th step is conclusion and resolvability assessment. And sixth part is monitoring and implementation agency, how it will be implemented. So these 6 steps are universal to any resolution plan, whether it is happening in India or in UK or in USA, the 6 steps remain same. So let us discuss these steps in little bit of a detail. So in strategic corporate analysis, you do the detailed analysis of CD, its structure, its legal form, its financial position, its business model, critical functions, internal and external dependencies, and critical systems and infrastructures. Now you have to see your resolution applicant who has come to you for doing a resolution plan for another CD, whether he fits into that particular form of organization or not, whether the business model complements your client or not, whether the critical functions he can handle or not, what internal external dependency in that particular CD are, whether your person can complement it, can he enhance something and add value to that. You should be very much clear about this thing. Then second is, what is the resolution strategy you are going to deploy onto that? So whether the objective of resolution are best served by letting the CD fail or by resolving it. So when person comes to you, he is so much determined to buy an asset that he says, "Yes, sasta mil raha hai, sir. Kindly purchase it." No, sir. So as a consultant or as a RP, you should be sure whether this CD is best to go as a going concern, or the CD is in such a state that it is best to fail. Now, why I'm saying so? I'm saying against the resolution plan, definitely. In one of the latest incidences, where one of the financial creditor approached me, कि जैन सर हमने आपको, we want you to be RP of this particular CD, which we are going to put up an application. So once I have seen that file, I said, okay, you bring in your dossier and your file along with you. I want to look into the company, what kind of a CD it is. Once I started looking into that CD was having a total obsolete technology on which the business model was designed. So if that CD is continued on that technology, means if you keep that CD running as a going concern based upon that technology, that is bound to fail ultimately. So what I suggested to that particular financial creditor, sir, look, this CD is not resolvable as a going concern, first of all. They said, why? Well, first of all, this company is not as a going concern right now, which the case you have come to me. Second thing, the technology involved into production of this CD is totally outdated. That is much more changed now. It can't survive based on this technology. It requires a complete overhaul and change in total plant and machinery and technology working. That makes it totally unviable. So this company will directly go to the liquidation rather than resolution. So you must be very much clear about the technology part. You must be very much clear about the strategy, whether you are going to resolve it or whether you are going to let it die. So in the later case, this step includes a detailed description of resolution strategy and instruments that will be applied. If you want to resolve that company, so how you are going to resolve it? Say the total outstanding claims against a company are 10,000 crore of rupees. Now you have to evaluate what kind of assets are there. The asset value for 10,000 claim company is say rupees 2,000 crore or 3,000 crore of rupees. Then there are certain suppliers which are very much critical to the survival of the CD. And their claim is also part of that 10,000 claim. Now, as per section 53, once you are going to run the waterfall model, the money is to be distributed among the priority as listed under section 53. Now, if you do the complete haircut to the critical supplier, he will never supply the goods to the company. Now, how you are going to handle that situation, how you are going to benefit that particular supplier. Now, these all things are to be made into the resolution plan, and how it is to be done, that is another question to be decided. You will see those resolution plans in practicality, or in another session, we will be discussing those. Then financial and operational continuity. So another thing that is more important is assessment of financial and operational requirements for ensuring CD's continuity both during and after the resolution. This includes continuation of CD's payments. Now, there are two phases. One is the CRP process phase. As far as the older claims are concerned, those are frozen as on CRP date. You need not to bother about that, because you are going to handle those claims by resolution plan. Either those will have the haircut, or you are going to pay by your resolution plan. That is not an immediate headache as far as the resolution applicant is concerned. But during CRP period, the RP is supposed to keep that company as a going concern. So normally what happens, the working capital requirement is so high, interim finance is not available at all in the company, and resolution applicant, they are normally chips into as interim financer. So whether as a resolution applicant, you are interested to be as participant into the company as a interim financer also, then what kind of a working capital requirement ultimately you will be having once the resolution plan is passed and into the implementation stage and post-implementation stage, and what kind of a capex you will be requiring to put into that company so that that company is ultimately running profitably. So all these things are to be pre-decided before preparing a resolution plan. Then information and communication plan. Majority of the plans, majority of the change in management fails because of lack of information, because of lack of communication of the change in management plan. Why I'm saying so? Because what I have seen in my practical experience in IBC, the COC, the RPs are unable to communicate the resolution plan in proper way to all these stakeholders. Not only COC members, because COC member knows what the resolution plan is, but there is another plethora of claimants, workers, suppliers, operational creditors, customers, all which are not part of COC are always looking at the CD, whether it is going to fail or whether it is going to revive. And RPs are normally mum onto that. They are unable to communicate the resolution plan or prospective resolutions to those people, and they get jittery. Once they get jittery, they start putting up lot of legal hassles to the resolution applicant, to the COC, to the RP. And you find lot of litigation in the courts of law. So the plan describes all rules and procedures for ensuring that COC and adjudicating authority receive all necessary information in good time. It also describes how the process will be communicated internally and externally before, during, and after the resolution. What I'll say here, our resolution process needs little bit of changes over here. We need to have a proper communication system of the resolution plan, which is there only after passing. Means as a RP, I am supposed to communicate to each and every stakeholder what he is going to get under resolution plan. And that is the wrong thing, because all the litigation is happening before passing of the resolution plan. So what, in my opinion, as a professional, is required today, that we propose the IBBI, we propose the Ministry of Corporate Affairs, that they come up with the guidelines, how the information about the resolution applicants, information about the resolution plan can be percolated among all other stakeholders who are not part of the COC. So that will ease out lot many litigations out of the whole process. Then conclusion and resolvability assessment. So this step is to determine whether there are any further obstacles to the CD's resolution. Once these has been identified, COC can impose measures on the CD to remove the obstacles. For example, Competition Commission note, any other licensing authority approval, statutory authority clearances, etc. So all those things, the statutory authority is a major headache today as far as the practical concerns are there. Lot many case laws are coming, lot many claims are coming after passing of the resolution plan. Majority of the courts have taken the decision, once the resolution plan is passed, everything is settled. But there are few judgments, especially the Rainbow case of the Supreme Court, where the claim was filed much later after passing of the resolution plan, and Honorable Apex Court allowed it to be as a secured creditor in an automatic way. The facts of the case, I will say, suggest that, but that case is now wrongly taken as a precedent in all resolution plan cases by all NCLT benches. Now, step 6, monitoring and implementation. So depending upon the situation, the resolution monitoring and implementation agency to the resolution plan is to be decided in the resolution plan itself. Resolution plus passing authority will consider this, adjust the plan if necessary, before formally passing it with or without modification if required. Now, there are few resolution plans I'll be discussing over here, which has passed and what kind of process they have passed. Binani Cement. So Ultratech Cement won the bid to acquire Binani Cement under resolution process. The plan involved a financial restructuring of Binani Cement's debts and infusion of funds by Ultratech Cement. Plan aimed to revive operation of Binani Cement, leverage synergies with the Ultratech Cement's existing business. But there was litigation. What litigation was there? During the resolution process, Binani Cement, a competing resolution applicant, Ultratech Cement, challenged the decision of the resolution professional to select Dalmia Bharat as the winning bidder. Ultratech Cement filed a petition before NCLT. NCLT against the decision, stating that its bid was more favorable to the creditors. The case eventually reached Supreme Court, which allowed Ultratech Cement to take over Binani Cement, setting a precedent for the primacy of the Committee of Creditors decision. Now, JP Infratech. This is one of the most litigated top to downward running resolution plan orders, I will say, and one of the most complicated plans. And incidentally, in one of the cases, I was also involved in one of the home buyer cases. So JP Infratech, the resolution plan involved takeover of JP Infratech by a consortium led by Suraksha Realty and NBCC India Limited. Plan aimed to complete the pending real estate project and address the financial distress faced by home buyers. So litigation was resolution process of JP Infratech witnessed significant litigation from home buyers who were seeking completion of their housing projects or refund of their investment. Supreme Court intervened and directed the resolution professional to ensure that home buyers' interests are adequately protected in the resolution plan. The court also ordered formation of committee to oversee the resolution process and protect the rights of the home buyers. Now, I tell you, this home buyer projects under CRP are very much different from the normal CRP processes. I tell you why. The home buyer process is very tedious and very difficult because you are, as a RP, dealing with, say, 1,000 or 2,000 COC members, not only 5, 10, or 15 COC members. Now, each and every home buyer, whether he is informed or uninformed, is having a preconceived notion in his mind or preconceived particular thinking about his in mind that how RP is working and how the loss is going to happen to all of them. Here, the proper dissemination of information comes handy to the home buyers and to the benefit of RP who is handling the case. So I always suggest as a RP, I successfully resolved one of the home buyer cases, almost you can say first of the resolution, 1 or 2 resolutions happened at that time of the home buyers, where the complexity, I tell you, what complex structure in home buyer cases are normally happening. Normally, the company like JP Infratech, I'm not naming JP Infratech, any builder, they are having this company which is not having the assets as such. Means the land is either allotted by a Gamada, Puda, UP authority or any housing board. That land is basically allotted for a partial money, say 10 to 20% or 25% money they receive from the developer, and they hand over the land to that developer to develop it as a project and sell it off. And they start receiving the sale proceeds. They have to pay back to the agencies who have allotted that land to that particular developer. Now, basically, that is a case where the developer has taken land from that particular agency, government agency. Here, what happens? Normally, these developers don't have the right onto the land as such, don't have the complete ownership of the land which they are selling. In between, they start diverting money to other projects. And they are unable to pay that money to the basic allotting authority. Now, what allotment letter normally says, if you don't make the payment, this much penalty will happen. If this much time lapse and you don't pay the penalty even, we will confiscate the land bank which has been given to you. So now complication arises. Once this thing happens, say Puda, Gamada, Huda, they start taking back their land. Now they have already sold the flats or plots on that particular land piece to various stakeholders, say the home buyers, who has invested their money into that land bank, which is not owned by the developer company. So these kind of complications happen. Another set of complication, what happens? The land is on the name of actual landowners, farmers. The developer does the pooling, means by paying certain amount to them, he takes a NOC from them and apply to the CTP department for approval of a say, plan for the plots or high-rise buildings, which is allowed under RERA even, and the project is registered under RERA, although RERA has come as a little bit support. Now the money can't go out of the project, and money is to be invested into the project, but implementation of RERA is not so strong right now. Even now, the promoters are diverting the funds out of RERA approved projects also. So in many cases, what I have seen, the lands are purchased in the name of various other small holding companies, land holding companies, and in turn, they do the agreement with the main developer company, which is the face, which is selling the plots to the home buyers or selling the property to the home buyers, and actual real estate is not in their hand. So here, the group insolvency concept comes into being, means the group of those corporates, group of those companies are to be clubbed together to put into group insolvency, and a resolution as a group should happen. So that group insolvency as such is missing, but a lot of court cases has now happened where project-wise insolvency is also there, or group insolvency can also happen as it happened in the Videocon case. Alok Industries. Now, Reliance Industries and JM Financial Asset Reconstruction jointly acquired Alok Industries through resolution process. Resolution plan involved financial restructuring and takeover of company by the consortium. Plan aimed at to revive the textile company's operation and leverage Reliance Industries' expertise in the sector. So many litigations happened. Resolution plan of Alok Industries faced litigation from dissenting financial creditors who raised objection to the distribution of funds and challenged the decision of committee of creditors. Matter was taken at NCLT and NCLAT for resolution. NCLAT provided clarification on the rights and of the dissenting financial creditors and upheld the decision of committee of creditors in approving the resolution plan. Now, Bhushan Steel. Now, here the Tata Steel successfully acquired the Bhushan Steel through resolution process. The plan involved financial restructuring of company's debt and infusion of capital by Tata Steel. Plan aimed to revive the operations of Bhushan Steel and enhance its production capacity. The plan for Bhushan Power and Steel had the legal challenges from multiple parties, including lender and operational creditors. There were the two rounds of litigations. First round, various entities with outstanding claims objected regarding the eligibility of the winning bidder, JSW Steel, and distribution of funds. The matter was litigated in NCLAT, leading to delays in the finalization and implementation of plan. Then litigation round 2 happened. After initial resolution plan for Bhushan Steel was challenged and set aside by NCLAT, the second round of resolution process also faced litigation. A competing resolution applicant, JSW, challenged the eligibility and decision of resolution professional to select Tata Steel as the winning bidder. The matter was taken to the Supreme Court, which upheld the decision of the resolution professional and approved Tata Steel's acquisition of Bhushan Steels. Ultimately, another thing happened in the Supreme Court of India only, that singles were ordered to transfer their capital to Tata Steel as per the resolution plan, which the latest judgment came. So now regulation 37 is the basic regulation which tells how to resolve a CD. Regulation 37 of the CIRP regulations. So that gives a complete picture and glimpse into the things, how a resolution plan can be made. So resolution plan shall provide for measures as may be necessary for the maximization of value of CD's assets. So how it can be done? transfer of all or part of assets of CD to one or more persons. Means acquirer, the resolution applicant, can provide in the plan that he will transfer all of the CD assets or part of CD assets to one or more persons. Sale of all or part of assets, whether subject to any security interest or not, means even if the assets are secured, resolution plan can provide out of that secured asset, some part will be sold and some part will be kept, or whole of the secured portion will be sold or unsecured portion will be sold. Another BA was introduced that says restructuring of the corporate debtor by way of merger, amalgamation and demerger. It is an outcome of one particular judgment which I'll be discussing later on, that why necessitated this to be entered in this regulation 37. Then substantial acquisition of the shares of the CD or merger or consolidation of CD with one or more persons could happen in plan. Then cancellation or delisting of shares of CD, if applicable, can be done. Satisfaction or modification of any security interest can be provided in the resolution plan. Curing and waiving of any breach of terms of any debt due from the corporate debtor can be cured by the resolution plan. Reduction in amount payable to the creditors happen. So normally this is the clause which is being used as a haircut. Extension of maturity dates or change in interest rate or other terms of debt due from the CD can be done. Amendment of constitutional documents of CD can be done. Issuance of security of the CD for cash, property, security, or in exchange of claims or interest or other appropriate purpose can be done. Change in portfolio of goods or services produced or rendered by the CD can be done. So regulation 37 basically gives you the complete glimpse. So what resolution plan can do? You can change the technology used by CD. You can obtain the necessary approvals from the state or central government. Now, another amendment which recently happened in September 22 is also very important in regulation 37. M is sale of one or more assets of the CD to one or more successful resolution applicants submitting resolution plans for such assets and manner of dealing with remaining assets. So this is a far-reaching amendment which was done into regulation 37. Before this amendment, only one resolution applicant or one resolution plan was possible in case of one CRP. But by way of amendment of 16 September 22, there could be more than one or two or three resolution applicants in case of one CIRP. Now, there is one precondition attached to this thing that is read with regulation 36B. You have to read it with regulation 36B, sub-regulation 6A of the 36B. If RP doesn't receive a resolution plan in response to request under this regulation, he may, with the approval of committee, issue request for resolution plan for the sale of one or more assets of the CD. Now, in my opinion, this M is absolutely fine, but this precondition of 36B 6A is a little bit damper. So RP can use it only when he doesn't receive a resolution plan in response to a Form G earlier published. So with the approval of COC, he can go in for multiple resolution applicants. Now this Edelweiss Reconstruction Company Limited versus Synergy Dore. This was basically that a merger amalgamation which was introduced because of this case. AA order dated 2nd August 2017 approving resolution plan was challenged on the basis that plan provided for merger and amalgamation, which is not permissible as violates section 30 subsection 2E of IBC. It was noted that the resolution plan may provide for merger or consolidation of CD with one or more person in terms of regulation 37(1)(c) of the CRP regulations. So basically, merger, demerger, and amalgamation was provided because of this litigation. So another case, GSW versus Mahinder Kumar Khandelwal. This is that Bhushan Steel case. Differential treatment was given in the resolution plan in respect of payments to OCs whose claims were contingent as opposed to OCs whose claims were not. NCLAT held that the appellant claims to be OC, but his claim has not been crystallized, which made him contingent creditor, and as such cannot claim equitable treatment with all other creditors. Now, what are the mandatory contents of the resolution plan? This has been modified on various dates. Regulation 38 was modified almost 4 to 5 times. So what is the mandatory content of a plan? Amount payable under resolution plan to the operational creditors shall be paid in priority over the financial creditors. To the financial creditors who have right to vote under subsection 2 of 21 and didn't vote in favor of the resolution plan shall be paid in priority over the financial creditors who voted in favor of the plan. So plan को क्या provide करना पड़ेगा? जो OCs हैं, they shall be paid in priority to the financial creditors once payout happens under resolution plan. Second thing, the dissenting financial creditors to the resolution plan should be paid in priority to all other financial creditors who has voted in favor of the plan. So this is the liquidation value which has to happen under this clause. A resolution plan shall include statement as to how it dealt with the interest of all stakeholders and OCs of the CD. Resolution plan shall include statement giving details if the resolution applicant or any of its related party has failed to implement the resolution plan. तो अगर resolution applicant को एक statement देनी पड़ेगी कि he or his related party has never failed in implementing a resolution plan in past. Plan shall provide term of plan and an implementation schedule, management and control of business of the CD during its term, adequate means for supervising its implementation has been provided in the plan, and provides for manner in which proceedings in respect of avoidance transaction, if any, under Chapter 3 of the fraudulent and wrongful trading will be pursued after approval of the resolution plan, and the manner in which proceeds, if any, from such proceedings shall be distributed. अब ये वाला रेगुलेशन एक सुप्रीम कोर्ट एंड हाई कोर्ट जजमेंट से काफी डिल्यूट हो गया है. That I'll be discussing later on. Provided that in this clause shall not apply to any resolution plan that has been submitted to adjudicating authority before the date of commencement of these 22 regulations. 14(6)(22) के रेगुलेशन से पहले में ये प्रोविजन की रिक्वायरमेंट नहीं थी. It shall demonstrate addresses cause of default, feasible and viable, provisions for effective implementation. It has provisions for approval required, and the time for the same should be mentioned. Applicant has the capability to implement the resolution plan. Now, we come to Regulation 39, approval of the resolution plan. Now, this is again a very important regulation which clarifies many of the things. Now, clause 1. A prospective resolution applicant in the final list may submit resolution plan or plans prepared in accordance with the code and these regulations to RP electronically within the time given in the request for resolution plans. Now, first thing you must read through is applicant should be part of final list, may submit resolution plan or plans. What does that mean? A resolution applicant can give n number of plans. He can give 1 plan, 2 plan, 3 plans, or 10 plans. He can submit n number of plans to RP electronically within the time given as per 36B. Then an affidavit stating that it is eligible under section 29A to submit the plan, an undertaking that every information is true and correct. If it is found incorrect or false, so he will render ineligible and refundable deposit will be forfeited and attract panel action. RP may, if envisaged in the request of the resolution plan, allow modification of the resolution plan received under SAG Regulation 1, but not more than once. So earlier, before this amendment of September 21, the resolution plan can be amended many times. But after this amendment, now the resolution plan, once submitted to the COC or to the RP, can be amended once only, not more than that. It can be amended for more than once only in case a Swiss challenge is applied. So another is 1B, the committee shall not consider any plan received after specified time, received from a person who doesn't appear in the final list, doesn't comply with the provisions of section 30 subsection 2. The RP shall submit to committee all plans which comply with the requirements of the code and regulations made thereunder, along with details of the following transactions. Now there is one catch. If you read through this regulation 2 of 39, it says RP shall submit to COC all plans which comply with the requirements of the code. Now that has now been clarified by the Apex code that RP is duty bound to submit all the resolution plans whatsoever he has received along with his due diligence report to the COC along with transactions which he has recorded, which he has found under section 43, 45, 50, and 66. These are the 4 sections for preferential, undervalued, extortionate, or fraudulent transactions. And the orders, if any, of the AA in respect of such transactions. Now, this is the judgment which I was talking about. Okay, how the proceeds of these 4 sections, whenever it is received, will be distributed. Now, the plan cannot provide how it will be distributed. Now, it is settled law. The amount that is made available after transactions are avoided cannot go to the kitty of the resolution applicant. The expectation that some more amount could come to the kitty was not present when the commercial decision was taken by the resolution applicant while agreeing to take over CD. The benefit arising of the adjudication of a burdens application is not for the CD, means corporate debtor, in its new avatar, since it doesn't continue as a debtor and has gone through the process of resolution. This amount should be made available to the creditors who were primarily financial institutions and have taken a haircut in agreeing to accept a lesser amount than what was due and payable to them. Now, Regulation 39, approval of plan, clause 3. Committee shall evaluate the plan as per evaluation matrix only. Records deliberation on feasibility and viability of each plan. And vote on all such resolution plans simultaneously. Where only one resolution plan is put to vote, it shall be considered approved if it is received requisite votes. So there is one more change जो यहाँ पे हुई है. Earlier, they used to take out H1, highest plan according to the evaluation matrix, and they used to put it on to vote. Now, by this amendment, you have to put all the resolution plans simultaneously to the voting, and whatsoever resolution plan receives the requisite votes. If there is one plan, if it receives requisite votes, it is termed as passed. If more than 2 or more plans are there, which receive the highest votes but not less than requisite votes, shall be considered as approved. If 2 plans receive equal votes but not less than requisite votes, committee shall approve any one of them as per tiebreaker formula announced before voting. तो जो हम evaluation matrix बनाते हैं, we decide that tiebreaker formula also in advance. So if there is a tie between 2 or more resolution plans in voting, then we apply that tiebreaker formula to announce who is the successful resolution applicant. Where none of the plan receives requisite votes, committee shall again vote on the resolution plan that received the highest votes subject to the timelines under the code. Any questions till now? We can discuss it.
So we have received certain questions, but maybe you finish the session, we'll take it together, sir. Will that be convenient?
Okay, fine.
Because loads of questions have come. The flow should not break. That's why I'm asking.
So actually, the plan is so complicated and things are so big. I can keep on continuing speaking on this.
Very true. We like to listen to most of what your content is, sir. Then I'll try to streamline all the questions and put it before you.
Okay.
Yes, thank you.
So how the plan is voted and how the things happen is before you on the screens. That is what the regulation 39 exemplifies basically. If 2 plans are put to vote, say A and B simultaneously, first outcome is, say, plan A receives 55% vote and plan B receives 60% vote. None of the plan is approved. The committee shall vote again on plan B, which receives the highest number of votes, subject to timelines under code. Suppose plan A receives 70% vote and plan B receives 75% votes. So plan B is approved at it receives a higher vote, which is not less than the requisite votes. Now, in third, suppose both plans receive 75% vote. All the COC members say yes to A and yes to B also with same percentage. Now, committee shall approve either plan A or B as per tiebreaker formula announced before voting. Now, Regulation 4, sub-regulation 4 of 39 says, RP shall endeavor to submit the plan approved by committee to AA at least 15 days before the maximum period for completion of CRP as per section 12, along with compliance certificate in form H of the schedule and evidence of receipt of performance security required under sub-regulation 4A of 36B. तो आरपी ने जैसे ही प्लान पास हुआ ट्राई करना है 15 days before of CRP ending, but at least as fast as he can do, he shall submit the resolution plan along with form H and performance security guarantee documents along with that to AA. Now sub-regulation 5 says, RP shall forthwith send copy of order of AA approving or rejecting the plan to the participants of RA. RP shall within 15 days of the order approving a plan intimate each claimant the principal or formulae as the case may be for payment of debts under the plan, provided that this sub-regulation shall apply to every CRP ongoing after 13/11/2020. A provision in the plan which would otherwise require consent of members wherever means जहां पे भी किसी के शेयर्स ट्रांसफर होने हैं, कुछ भी होने हैं, कॉन्स्टिट्यूशनल डॉक्यूमेंट चेंज होने हैं, दैट विल बी डीम्ड एंड ओवररूल्ड. कोई शेयर होल्डर एग्रीमेंट है, जॉइंट वेंचर एग्रीमेंट है, दोज ऑल आर overruled by the resolution plan. No proceeding shall be initiated against IRP or RP as the case may be for any actions of the CD prior to the insolvency commencement date. So it is a ring fencing to the professionals like us that anything which is being wrongly done by the CD before commencement of CRP shouldn't affect you as RP. So no case, no proceedings can be initiated against you for the things which happened prior to insolvency commencement date. A person in charge of management or control of business of CD after plan is approved by AA may make an application to AA for an order seeking assistance of local district administration in implementation the terms of resolution plan. Now, during implementation period, say certain people don't want the RA to take control of CD, say workers are agitating, say promoters are putting impediment into the takeover of that company, then whosoever is in charge of management of the CD during implementation can go to AA for getting a assistance from police force, local district administration against those people. So a creditor who is aggrieved by non-implementation of plan approved under section 31 may apply to adjudicating authority for directions of the same. Means where there is a failure in implementation of plan, any creditor can trigger the application before AA. So prior approval, preservation of record, I will not. All the records of the CRP are to be preserved by RP for minimum period of 8 years, physical copies to be maintained for 3 years, and all electronic record for 8 years. Along with the resolution plan, there are other resolutions which are very important to be put into agenda and to voting are meeting of liquidation cost. Now, this is the most difficult part when you tell the COC that you have to vote on other agendas other than the resolution plan, that is on the liquidation cost, how under liquidation company will be sold, how the liquidation expenditure will be met, and all those things. So they say we are voting on to resolution plan, but there is always slip in between cup and lips. That is what RP should take care. That is what the regulation says. So what it says, if the company's resolution plan is failed, resolution plan is not passed, company slips into liquidation, plan is passed by COC, not approved by the AA, plan is approved by COC as well as AA, but not implemented by the resolution applicant, the company will slip into liquidation. So if that happens, from where the money will come? So RP has to make the best effort to judge what kind of a liquidation cost is going to happen in case liquidation happens in this company, and what kind of a liquid assets are available in this company. So if the liquid assets are less than the liquid cost, then that money, liquid cash, should come from the financial creditors in their sharing ratio. So that resolution is also put to vote along with the resolution plan. Then another thing, the regulation 2B was introduced in the liquidation regulations due to a S. Shekaran case decided by NCLAD that compromise and arrangement is possible under IBC, even under liquidation process. So due to that judgment was basically impedient, or that basic judgment found way into the regulations itself. Liquidation regulation 2B was introduced, and regulation 39BA was introduced into CRP regulations. So they say the RP or the liquidator should first try to resolve the company either by way of resolution or by way of 12A. If it is not possible, then by way of compromise and arrangement. And in liquidation, compromise and arrangement is possible. So before start of liquidation, there should be a period given under 39BA for compromise and arrangement. Means if promoter is doing compromise and arrangement, shareholders are trying for compromise and arrangement, they should be given time to do that. So while deciding to liquidate CD under section 33, COC shall examine whether to explore compromise or arrangement as referred under sub-regulation 1 of regulation 2B of the liquidation process. RP shall submit the COC's recommendation to AA while filing the application. Means COC shall discuss on this matter, should vote on this matter, whether they are ready to get into any kind of a compromise or arrangement. If they are ready, how that will be done, and immediately that process shall start. And liquidator whosoever appointed, how much fees he will be paid during that period of compromise. Then another thing, if liquidation happens, so if the company is a going concern or the unit is a good or a working unit, whether there can be sale as a going concern possible. That is under regulation 32 of the 32E and F. E is basically 32E of the liquidation regulation is basically sale of a company as a going concern under liquidation. That was also introduced in this amendment only. So COC has to decide if the company slips into liquidation, whether they are advising the liquidator who will be coming that he should try to sell that company as a going concern. So where COC recommends for sale of company as a going concern, it shall identify group of assets and liabilities, which according to the commercial consideration ought to be sold as a going concern under clause E or clause F of regulation 32 of the liquidation process regulations. The RP shall submit the recommendations of COC to AA while filing the approval or decision of the committee under section 30 or 33 as the case may be. Then the fee of the liquidator. So liquidator fee is to be decided in the last COC meeting itself, whether how much fee is to be paid if the compromise arrangement is done under section 230 for that period. Then for the period, the liquidator will try to sell that company as a going concern under regulation 32E or F. Then for the balance period out of 1 year, these time will not reduce. Then another period of maximum 1 year will be given, and balance period of liquidation, whether liquidator has been decided and a fee has been decided that this much fees will be given. If nothing is decided, then the fees of the liquidator will automatically go through regulation 4(2)(a) chart of the liquidation regulations. Now, section 30 says submission of the resolution plan. RA may submit a resolution plan along with the affidavit of 29A. Then he provides for the payment of insolvency resolution process costs in the manner specified by the board, provides for payment of OCs in the manner specified by the board as we discussed earlier in the regulation. Then all the dissenting financial creditors, provides for management and affairs of the CD after approval of the plan, implementation and supervision of the plan, do not contravene any of the provisions of the law for the time being in force, conforms to such other requirements as may be specified by the board. Now, I will just skip through these certain things which are very time consuming and we have very short time. How much time we have for the discussion, for the queries?
So we can take queries for 15 minutes. Is that okay? So maybe
So another
40,
10,
440, is that okay for you, sir? Till 440 you can take the session.
Okay. So I can continue with the subject for at least 10-15 minutes more then.
Yes, sir. Yes, sir. If required, we will stretch a bit also. No issues.
Okay. No, this is the most difficult thing the RP has to see into a resolution plan. There are certain judgments which I'm quoting over here. The resolution plan can contain provisions for delisting of securities, and any permission of SEBI is not required because delisting regulations are present. Equity SEBI delisting and equity share regulation 2018. But Reliance Industries versus Ajay Joshi case, it has been held that resolution plan can contain provisions of delisting of security and any permission of SEBI is not required. However, there is one provision of that regulation which has to be kept in mind. That is minimum 5% public shareholding. If company continues to be listed after resolution plan is to be maintained. So every listed company shall maintain public shareholding of at least 5% as a result of implementation of a resolution plan approved under 31 of the IBC. Means now, if you are not going in for delisting and you want to continue the company as a listed company, then in the reduced capital and enhanced capital by the resolution plan, minimum 5% of the public shareholding should remain in the listed company if you want to propose that company in your plan as a listed company. Now, resolution applicant has to submit an affidavit pursuant to section 30 subsection 1 that code its eligibility of 29 is there. Contents of SEB can be certified by RP. I'll just pass through these. We have already discussed these regulations. Now resolution plan before AA. If AA is satisfied that plan as approved by COC meets requirements as referred to section 30 subsection 2, it shall by order approve the plan. So AA shall, before passing an order of approval of plan, satisfy that plan has provisions for its effective implementation as per proviso to section 31 subsection 1. The plan so approved shall be binding on CD, its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. The copy of approved resolution plan shall be sent by RP to participants as per regulation 39 subsection regulation 5. After order of approval by AA, a moratorium order passed by AA under section 14 shall cease to have effect. The RP shall forward all record relating to the conduct of CRP to be recorded to IBBI to be recorded in its database under section 30 subsection 3. After resolution plan is approved, approval of some other authorities may be required, for example, Competition Commission of India, land regulations of state or regulatory authorities. The resolution applicant shall, pursuant to the plan approval, obtain necessary approval required under any law for the time being in force within a period of 1 year from the date of approval of the plan by AA under 31 subsection 1, or within such period as provided for in such law, whichever is later. ये मैं पहले ही आपसे डिस्कस कर चुका हूं. Now, if resolution plan is rejected by NCLT, so appeal against order of AA from an order approving a plan shall be in the manner and on the ground specified under section 61 subsection 3. Appeal can only be on the ground specified in that section. That is, the plan has been approved by way of a fraud or misconception. Only on that grounds it can be challenged. Now, few other important judgments. Now, can plan propose liquidation? And this is a very interesting case decided by NCLAT, decided in the matter of government company only, Industrial Services versus Burns Standard Company Limited. Resolution plan is to provide for revival of CD. जब हमने definition सबसे पहले पढ़ी थी, वो क्या कहता है? The resolution plan should provide for company as a going concern. Resolution plan should provide for revival of CD as a going concern, not for its closure. Another case, whether resolution plan should be given to the suspended members of board of directors of CD, means ex-promoters. Here, in this particular judgment, the Supreme Court held Vijay Kumar Jain versus Standard Chartered Bank. Supreme Court recognized the right of the members of suspended board of directors of the CD to receive the insolvency resolution plan submitted before the resolution professional in order to effectively participate in the meetings of committee of creditors. तो ये RPs के mind में, COC के mind में कई बार रहता है whether to give the resolution plan to the ex-members or promoters or not. So, by Supreme Court judgment in this particular matter, it is impeding, it is basic responsibility of the RP to provide the resolution plan also to the promoters. Now, this Siri multiple asset investment versus Deccan Chronicles. This is again Supreme Court judgment, very important judgment. Once resolution plan stands approved, no alteration modifications are permissible. Resolution plan is either to be approved or disapproved but any modification after approval of plan by COC based on its commercial wisdom is not open for judicial review unless it is found to be in contrary with the mandate of IBC. Then Vistara versus Dinkar Venkateshwaram. Here the Supreme Court says the interest of the creditors who are not included in the COC, that is the operational creditors and financial creditors who have not voted in favor of the resolution plan, must be protected in resolution plan by the RP and adjudicating authority. Therefore, a resolution plan cannot dilute, negate, or override a pledge agreement because a resolution plan to this effect has been approved by COC without the pledgee as its member. In such a case, pledgee is to be treated as a secured creditor who would be entitled to all rights and obligations as applicable to the secured creditor in terms of section 52 and 53 of the code in accordance with the pledge agreement. This is a very interesting judgment which differentiates between financial creditor, operational creditor, and operation of section 52 and 53. Why I'm saying so? In all of the IBC, we read through operational creditor, financial creditor, and normally in our mind, we think financial creditor is the secured creditor, operational creditor is the unsecured creditor. Now, once we reach to section 52 and section 53, and we read through 53 waterfall to be specific, there is no word of financial creditor and operational creditor listed over there. It only says secured creditor or unsecured creditor. So this judgment basically clarifies the operation. Even if the operational creditors who is pledgee in this particular case and not being part of COC can't be taken out of waterfall model as being secured creditor, being not part of COC. He will remain as part of secured creditors. Now, this is the main judgment which is creating the problems which I discussed. State tax officers versus rainbow papers. This is a Gujarat VAT case. Gujarat VAT for section 48 had a very different kind of a provision, which says it automatically creates the security interest wherever an order is made. And in this particular case, the GVAT made an assessment, attached the assets of this rainbow papers, and Supreme Court ultimately said GVAT is a state and it becomes a secured creditor due to GVAT operation of the code act itself. And here 238 of IBC will not override, means GVAT will be sustained as a secured creditor. So now most of the NCLT benches, taking cue from the rainbow papers, are trying to make all the statutory dues as secured creditors. And we have to differentiate the circumstances. We have to differentiate according to the act in which they are operating, whether they have such provision or not. And this judgment is really creating trouble in the waterfall mechanism as such. Then Shiri Metallics. This is almost opposite judgment to the rainbow papers. And here the rainbow paper has been distinguished. I'll be having a little break of 1 minute.
Of course, sir, of course. No issue.
I'll be having 1 minute break. You can just have a little bit of discussion in between, just a minute break.
Sure, sir, sure. No problem, no problem. So all the participants, I hope you are having a good, insightful session here. So if you have any more questions, we have received loads of questions. We are trying to refine them. If you have any more questions, please feel free to post them on that box on the website. And questions relevant to the topic will be given preference in a way so that sir is able to explain on the topic. But we'll take as and what we can take subject to the time permit. Till the time sir comes. So I'll just like to showcase why this is important for professionals. So resolution plan preparation has become a separate, practice domain in itself, and it involves a lot of skills, efforts, and good knowledge on the law, on the code, and on the balance sheet, and on the strategy, basically how you are going to run the company. So chartered accountants can act as advisors to the resolution applicant. They can help a resolution applicant prepare a resolution plan. They can, help them comply with the mandatory contents of the code, section 30, subsection 2, also the CRP regulation, and help them draft a plan which is foolproof and which is compliant with the code, so it doesn't get rejected. And there should not be much of queries in the resolution plan. And we as chartered accountants are acting as RPs. We should know how to evaluate the resolution plan. We should know what are the mandatory contents which should be complied with, what are the developments in law. Like we have multiple honorable Supreme Court judgments which are coming, which are impacting the resolution plan process in some way or other. Let it be employee dues, let it be some implementation cost, how to implement, whether there can be modification in resolution plan or not. So we have to be up to date on all the amendments and all the developments in the code. And we also should be able to evaluate a resolution plan from financial per se. So the COC will definitely require the resolution professional's help in evaluating the NPV value. What money am I getting right now as on date? So the plan might contain a upfront payment, it might contain a deferred payment mechanism, right? It might have an equity upside. There are many things which can be factored into a resolution plan. We all know how evaluation matrix is being prepared. We have a model evaluation matrix from IB also. So loads of components are put there. Apart from qualitative parameters, you also have quantitative parameters. So in case there is some legal case going on where the COC feels there's adequate recovery, might be they might want to negotiate a percentage of the recovery. So we as RPs, chartered accountants, we should know how to evaluate the resolution plan and help COC. We should facilitate the decision making. As sir is rightly saying, our role is to facilitate the decision making by the COC. We are there to implement the plan and we are there to help the COC. Over to you, sir. You're fine now, sir? Over to you, sir.
I hope the session is not heavy and
I'm loving it, sir. I'm sure everybody else is also loving it. Many questions are there.
yeah. The Shri Metallics, this is a little bit relief where the Delhi High Court, Honorable High Court, has distinguished this rainbow judgment. So where pursuant to the initiation of CRB, RP invited claims from creditors. However, respondent Director Revenue Intelligence had not submitted any claim before RP to recover unpaid custom duty to be paid by the CD. And the meanwhile, resolution plan was approved. Right of the respondent to recover amount due had extinguished. Rainbow paper is distinguished in para 50 of this judgment. Clearly, as noticed above, the judgment rendered by Supreme Court is distinguishable on facts, they say. In para 50.1, they say the instant case of DRI DGFT neither submitted a proof of claim nor responded to the specific communication email dated 17/5/17 addressed to the respondent number 3. In contradiction, in Rainbow papers, a claim was lodged in the prescribed form, albeit after the last date of submission indicated in the public announcement by IRP, but before NCLT had rendered a decision in the matter. So here the High Court says the cases of the Rainbow paper is distinguishable on the matter of facts. It should not be taken as a complete law in itself. In Rainbow paper, the claim was filed. Attachment of assets has happened. That is why they become the secured creditors. But being a statutory authority, you don't file the claim. You don't do any attachment. You automatically doesn't become the secured creditors. Now, MK Rajgopalan versus Dr. Bismay Palani. This is again Supreme Court judgment. Non-provision for related party creditors in resolution plan doesn't violate any provisions of the law nor the principles of non-discrimination. Now, this judgment also has a totally different facts. So it should be read in a different perspective or such. Section 53 as such doesn't distinguish between related party and non-related party. Nowhere it is mentioned in the section 53, the related party and non-related party creditors should be distinguished. But this judgment is totally contrary to that by the Pax Court, but based upon certain facts. So you have to go by the facts of the case in totality, not by simply by reading through the judgment. So when it is noticed that the promoter and erstwhile director, the contesting respondent has been holding the position of chairman of the said related party, it has to be held that NCLAT has erred in applying the principles of non-discrimination and thereby holding against the resolution plan in question for the want of provision for related parties. So here they say, agar related party ko kuch nahi mila plan mein, water flow mechanism mein usko bahar nikal diya, so there is no violation of law. As such, this judgment says this. Now, this is the judgment of NCLT Indore. CD was admitted into CRP by AA. Plan was submitted by successful resolution applicant approved by COC with majority. Same was submitted before AA for approval. Lender bank and few other creditors objected to the said resolution plan as it sought to extinguishment of liabilities of the personal guarantors of the CD. Now, लोगों को लगता क्या है कि resolution plan में अगर promoter या उसका adjoining कुछ भी ऐसा plan लेके आए जिससे वो अपनी personal guarantees को extinguish कर ले. So now that has been struck down. COC could take any commercial decision relating to the CIRP. However, it could not extinguish right of the dissenting creditors to proceed against personal guarantor of the CD under grab of its commercial wisdom. And such provision in resolution plan was not only prejudicial to the rights of the creditors, but also the provisions of the law. Now, again, this Delhi High Court judgment. Petitioner stood as guarantor to the loan advanced by respondent, bank to the borrower. CRP was initiated against CD. Plan accepted by COC was approved by NCLT. Under approved resolution plan, resolution applicant was to make payment to the respondent, but it defaulted. Resolution applicant defaulted in implementing the plan. Thereafter, proceedings were initiated by the bank under Section 13, subsection 4 of SURFACE Act, and in furtherance thereto, proceedings also instituted under Section 14 of SURFACE Act for taking possession of the security offered by the guarantor also. Petitioner was aggrieved by such action of the respondent bank, whether if petitioner was not absolved of his liability proceedings initiated by bank under SURFACE could not be held to be unconstitutional or in derogation of approval order of NCLT. It is held yes. Respondent bank certainly had right to proceed against collateral securities for the recovery of its dues, which were independent of the resolution plan approved by NCLT. So, whether if Parliament in its wisdom has only provided a remedy of liquidation process under 33(3) as a consequence of non-implementation of plan by the concerned CD, the High Court cannot create another remedy just because afternote remedy is not sufficient or suitable for the petitioner. Now, ये टूरिज्म फाइनेंस कॉर्पोरेशन 138 केसेस लोगों को दिमाग में ये रहता है, एक बार मोरिटोरियम लग गया, रेजोल्यूशन प्लान पास हो गया, 138 cases goes. No, sir. There is a catch in this. After passing of the resolution plan under Section 31, AA, in the light of provisions of Section 32A of IBC, the criminal proceedings under Section 138 of the NI Act will stand terminated only in relation to the CD if the same is taken over by the new management. 138 proceedings in relation to the signatories, directors who are liable or covered by two provisions of the Section 32A1 will continue in accordance with the law. Means जो directors, promoters और signatories ने वो check sign किए थे 138 में, they will continue to be liable. Company as such absolve हो जाएगी. Contingent claim. This is another issue which is very much prevalent in the resolution plans. And Sapurji Palonji ka case hai ye, Anclad New Delhi ka. This claim was subject to arbitration, and arbitration mein koi order nahi aaya. So resolution plan never provided for anything. The Anclad says there is no illegality in order in approving such resolution plan. So contingent claim is basically not taken as a claim at all. Now, settlement versus resolution. There is always a settlement proceedings which promoters continue along with the resolution plan when it is happening. So in this Vishal Vijay Kaltarni case against RP of Dikchi Port Limited, Anclad upheld approval of the plan submitted by AZPZ by holding that commercial wisdom of COC in approving the plan was not amenable to judicial review on the argument that settlement offer of the promoter was superior to the resolution plan approved by COC. Impugned order didn't require any interference. So, एक IBC Singapore Private Limited judgment of Supreme Court is very important. You people can read through this judgment. Basically, this judgment says, ये judgment आई Corona delay of NCLT handling the resolution plans, where the resolution applicants started running away from the already approved plan of the COC, which were before the AA or other authorities. They were trying to change the resolution plan. They wanted to change the resolution applicant as such, or they wanted to get out of the resolution plan as such. So IBC Singapore Private Limited Supreme Court judgment say nothing doing. AA doesn't have any authority to wriggle out any of the resolution applicant from the resolution plan which has been submitted and approved by AA. So, sir, almost there are actually host of judgments I can keep on speaking
Right,
on these judgments.
And nothing has crystallized, we can say.
Yeah.
It's an evolving subject. If you permit me, I'll pose the questions to you,
Yes,
sir.
we can start with the question answer session.
Great, sir. Great, sir. Thank you, sir. That was a very informative session. You
Yeah.
cannot finish this session or topic in one
Yeah.
2 hour slot. It can't
You need whole day to handle this thing actually.
Correct, sir. Even a 2 day slot will be less for this. It's a very engaging subject. Plus, it has a lot of, I was telling the participants, it has a lot of professional opportunities, both from the side of advising COC members or resolution applicant or the RP. A chartered accountant can, play a lot of roles here, and a lot of opportunities are there. We just should know our capabilities, try to upgrade our skills. We should embrace all these developments, all these Supreme Court judgments. I will be very frank. I
IBC
keep
has
a lot of judgments. I'm not
opened lot of areas of
Yes.
practice to the chartered
Practice.
accountants.
True,
You
sir,
can
and we should
appear
step
before
up.
NCLT. I normally appear before NCLT for arguing the matters.
Okay,
Then
okay.
you could qualify yourself as IRP, RP. Then you can act as a valuer and qualify as a valuer from the institute.
Yes.
Then you can act as a consultant to the RP. You can act as a consultant to the RA. You can act as a consultant to the promoters. You can act as a consultant to COC.
Yes. Sky is the limit, sir. Sky
is the limit under this act.
Of course, even 12A proposals, where
Yes.
you can CS can help the promoters
Yes.
do 12A proposals, all the
Definitely.
COC. Lot of opportunities are there, but we should be aware of the developments. I keep reading judgments. I am abreast with developments, but many cases which you showed, sir, I never seen them, right? It's a learning experience for me also, and it's very interesting. I saw one case on Dinkar Venkat Subramaniam on the pledge aspect. That's very new for me. It's very interesting, sir. So first of all, thanks for taking out your time. It's a very insightful session. I'll just post relevant questions to you, and you can take them one by one, sir. So I'll start with the questions. You won't believe we've got more than I think 75 questions on hand I have.
Surely.
Rita ma'am and I have refined them.
I'll, to my best of my knowledge, I'll try to answer all those questions.
Yes, sir. Yes, sir. It's a dynamic concept, sir. It's a dynamic area. So nobody can give a perfect answer in these questions. Right, sir. I'll start with the questions.
Yeah.
The first one is, sir, it's a bit away from the topic, but it does come in the entire context. If an operational creditor claim has not been considered, what remedy does he has when a resolution plan has been approved?
Yeah, if resolution plan has already been approved and the operational creditor filed his claim before approval of the resolution plan, he always has the remedy to go to NCLT against the order of RP or non-order of even RP. He can go to the NCLT against passing of that resolution plan. If plan has already passed, he can go under section 61 to ANCLAT that passing of the resolution plan is wrong without considering of his claim, which was filed before the passing of the plan by the COC. If the claim was filed after passing of the resolution plan by the COC, then his claim will not be considered.
Right. So in this, just to add on to the question, if the operational creditor is not getting, other operational creditor are not getting paid anything in the resolution plan because liquidation value is not generally zero, then is it advisable for them to stretch litigation in NCLT because they will also be incurring litigation costs?
Yeah, only in the case where the operational creditor has relevant documents in his hand and information with him that something hanky-panky has happened between the resolution applicant and COC members, and the company was totally undervalued. He has the relevant documents to support that the resolution plan passed by a forgery or fraud, then only he should continue the proceedings.
Right. Right.
Otherwise, there is no fun in getting into that litigation. He will lose.
Right. Right. Another question is, what strategies should be undertaken by RP to maintain going concern status? Why this question is coming up is we've said that the plan is defined that a plan to ensure going concern of the corporate data. So how should RP maintain the status so that a plan comes which takes the status forward? Sir?
Yes. This is one of the best questions I have received from non-RP sites. Yeah. So IBC is such a beautiful piece of legislation introduced. It has inbuilt section 14. That is the moratorium being announced on the date of order itself. What does that actually means? As a RP, I am entering into a company which is under operation. Bank is onto his head. All creditors are sitting on the head of the promoter and sitting inside the company that they should pay their dues. Now, by order of NCLT, all those claims are frozen. Means you can't take any money out of that company till the CRP process is running. Means as a RP, as a professional, I have a total calm period. I need not to bother that I have to pay any principal or interest. I need not to bother that I have to pay any of the previous dues of this company. Now a fresh slate plant is before me, which I can run for the payments I will do for the work I'll be doing during CRP period. So whatsoever goods I'll be getting during CRP period, from the sale proceeds, I'll be paying off those creditors during the CRP period. So this calm period basically helps a RP to keep a company as a going concern because you need not to bother for the earlier claims.
Right.
So that is the beauty of IBC.
Yes, moratorium does help. So even section 14, subsection 2A, it says that if something is critical and RP identifies that service or goods is critical, then that should not be suspended or terminated.
Yes.
That helps to maintain the going concern status. Yes, sir. The next question is definition of resolution plan covers amalgamation and merger. So if the corporate debtor is merged in the resolution applicant through the process of resolution plan, whether section 79 of Income Tax Act 1961 for carry forward losses will be applicable or not?
Yes, because exception has been carved out in section 79. 79 was itself amended later on, which says if the plan is passed through NCLT resolution plan and plan provides for continuation of the losses, the benefit of losses will continue.
Yes. Thank you. Next is another general question, sir, but very important. So they say one of the big challenge in CRP is managing affairs of the company. And the challenge is even bigger if the company is large. How do you think an RP could work out ways or methods in managing affairs of such companies? So how do you deal if it's a large entity?
Yeah, the RP is supposed to have a very big team now for handling that kind of CRP processes. There you should have support of very big team of professionals from that particular domain. Means you're getting into a steel industry, you should have a technologist, materialogist with you and every person who can run that kind of a company. Then you have to take support of the existing management and existing people who are in that company. Try to have a committee kind of a atmosphere for running that company. Means from existing employees, mix your own personnel into that committee, say make purchase committee, sale committee, R&D committee, critical committee, where your 1 or 2 person are part or chairman of that committee, and all the professionals which are already deployed into CD are taken into that committee. Then now make the rules how that committee will operate, how the minutes of every committee meeting will pass on to the resolution professional. He sees all the things are going according to the rules he laid down to how the committees will operate. If that starts working, the company starts automatically operating under CRP.
So delegation of authority.
Yeah, delegation of work is must.
Decentralization is the best mantra to do a large entity.
Yeah.
Right, sir. So one interesting question. So we are talking about claims on RP, right? Claims submitted to RP. So there is a contra question. Under which section of IBC, RP can file claim against debtor of corporate debtor who refuses to pay for goods supplied during moratorium? So if I have supplied goods as a corporate debtor, it might be during moratorium or before moratorium. How do I recover that money from my debtor?
From
It's
your
counterclaim.
you can always you can always apply for CRP of that company. All the section 11 will
Across
come
the
into
threshold.
being. Section
Across the
11.
threshold.
Yes, but there are instances and case laws which allow that,
Yes,
which
sir.
allow that also.
So we've also generally seen that when there are good heavy debtors on the books of account, and RPs are advised to write to all the debtors the day he takes
Yes.
into office for
Yes.
recovery of money, because
Yes.
that's going to reflect in the valuation report also. Even
Yes.
the valuers are going to ask
Yeah.
what efforts you made to recover money.
Yeah.
Some debtors might refuse, they might say it's contingent. Some might even, listening to NCLT and the RP in court officer, they even pay out. So we've seen debtors paying out also. I
Yes.
think first step we should be writing to them, not threatening them, writing to them, telling about our condition, our CRP, requesting them to pay back, and then take
The
the due
question
course
I
of.
think so was asked the goods supplied during CRP period.
So it says good supplied before insolvency also, sir.
Before insolvency.
For me, it's a debtor, so it doesn't.
Yes, then it is.
Whether I
Then
supplied
you
before
have
or
to
after.
chase them. You have to keep on
Yes.
sending them emails. You have to keep sending them the legal notices even for the recovery of money.
Yes, sir. Right, sir. The next question is, sir, it looks quite interesting, sir. In fact, I wrote this question, sir.
Then it must be
My
very
personal question. So
ticklish
this
one.
falls out from rainbow paper judgment, sir. We all know what kind of complications it has added on to already the set of complications which are there. So section 30 of insolvency and bankruptcy codes, the resolution plan section, it requires operational creditor to be paid at least the liquidation value, correct? Which we derive from section 53.
Yeah.
Now, in this judgment, the VAT department of Gujarat in this case was made a secured creditor because they filed their claim on time, and the Gujarat VAT Act makes them a secured creditor. So they are made a secured creditor. Now, when a resolution plan comes, suppose in the state of Gujarat, right? So the resolution plan should provide for liquidation value of operational creditors. Now, Gujarat VAT department might say, I am a secured operational creditor and my ranking will be pari passu with the secured financial creditor in section 53. Because as you rightly said, 53 doesn't differentiate between secured operational, secured financial. It simply says secured creditors. So when that happens, in a resolution plan, you don't normally see government dues getting paid. There is always a bucket is there, operational creditor, financial creditor, unsecured financial bucket is there. SR, seal judgment, Swiss ribbon, it all allows for, if there is an intelligible differentia, we can create buckets and there can be different payments. So suppose I as a resolution applicant say that secured FC, I will pay X amount. Secured OC, which are government dues, I will not pay anything. Is my plan non-compliant with the law, sir?
No, not at all. Because your plan is providing according to section 53 only. If the operational creditor is secured, then he has to be paid according pari passu or whatsoever pre-ratio is to be maintained between those. Because the 53 doesn't say the financial creditor or operational creditor. It says secured creditors.
Okay.
So Gujarat VAT becomes secured creditor. And financial creditors are also secured creditors.
Okay.
Now you have to read through section 77 subclause 4 of the Companies Act.
Charge, that's on the charge. Right.
Yes. Now, as a liquidator, once you are operating that company under liquidation, then the liquidator is supposed to read through section 77 subclause 4. Now, since distribution is done in accordance with section 53 and section 30 was amended for the applicability of 53 onto that.
Yes.
Now,
yes.
with section 30, you read section 53, read with section 77, subsection 4, you have to distribute in pari passu manner only.
Okay, but we generally don't see that because the plan generally doesn't pay operational creditor, specifically the government dues. Even our preamble of
That
IBC,
is why I clarified 53 is totally different from whole of the code.
Correct.
53 talks about only secured and unsecured, not operational and financial.
Yes, sir. This has resulted in some more complication because the VAT department wants to be treated inequality with the secured financial creditor, but applicant does not want to give that much to the statutory dues. Even our preamble.
Another question will be put to rest by an judgment which will come in later days.
Okay.
It is not the duty of the resolution applicant to distribute the money.
Right. COC.
Yes, it is the COC's duty to distribute the money offered by the resolution applicant.
Correct.
So
Correct.
resolution plan has nothing to do with the distribution of the money. It has been offered under the plan.
Right. Right.
So resolution plan has to just take care of, as per their estimate of liquidation value, the portion going to the operational creditor and to the center financial creditor. That's it.
Right, right. We'll await more clarity on this. Our own preamble to IBC says alteration in order of priority of payment.
Yes.
Right, sir. And that alteration has kind of got complicated with the rainbow judgment, because again you push the government dues up in the first. Okay. I'll move on to the next question, sir.
Yes.
I was just thinking yesterday, and this question came up. I thought I'll put it to you. So next question is, if group insolvency is outside IBBI is being done by Supreme Court, and there is NCLT order for CRP individually, then how to proceed? A bit off the topic, sir. So basically they're saying if Supreme Court is doing a group insolvency and there's NCLT order in the components, then how to proceed in that case?
So if groups insolvency is happening under Apex Court itself, and the company which is not part of that group insolvency before the Apex Court, and the NCLT AA passes the CRP order in that case, then CRP for that particular company will run concurrent to that group insolvency.
Okay.
Now, in another way, if Apex Court is running group insolvency and the CD against which any application under section 7, 9 or 10 is pending before NCLT, then NCLT can't pass an order of CRP once group insolvency is underway before the Apex Court, including the CD, which is before AA.
Okay. Okay. That's quite interesting, sir. I mean, these are cases which are very rare.
Yeah.
The next one is, sir, after a list of potential resolution applicant is finalized and date of submission of plan has been extended, in the interim, if there is an OTS between COC and the corporate debtor and the applicant, who is one of the members of the COC, and they apply for withdrawal of CRP with requisite majority, then is the doors closed for the other PRAs, or can they be given an opportunity to offer a better scheme than the OTS offered by the corporate debtor? So basically, they're saying in the process, an OTS has been received. Now, what about the PRAs who are already there in the process?
Yeah. In case before passing of a resolution plan, Section 12A happens, then Section 12A application RP is duty bound to file it immediately. Then no chance, because resolution applicant doesn't create any stake till the time the resolution plan is passed. So any PRA doesn't have any stake in the CD till the time the plan is passed.
Right. Sir. So the next question is, in case of listed entities, resolution plan can contain delisting procedure, but practically there are many challenges in giving effect to delisting. Can you tell the best and tested approach for delisting provision in the resolution plan?
The resolution plan can directly provide for the delisting provisions, but you have to go through the section 53 mechanism again. Suppose your resolution plan or the liquidation value trickles down, say 1 cent to the equity shareholders also, as per 53. Then before getting into delisting under section resolution plan, you have to satisfy the distribution according to section 53 at that level.
Right, sir.
If nothing is tickling down as per your resolution plan, then you can straight away term it under delisting in your resolution plan. No provision of delisting regulation will apply, because 238 will have override the judgment I have already shown to you.
Right, that's true, sir. But still, we face practical challenges with the stock exchanges, where earlier dues are pending and it doesn't get, the file doesn't move.
All dues are according to the section 53 is to be dealt with.
True, sir.
And they have to take cognizance of the AA order, where the resolution plan says the company will be delisted.
Correct. It's binding on all
It
stakeholders.
is binding. It is binding. It is automatically binding.
So can a home buyer get back money paid by him with interest where he is not interested to go for a resolution plan, where a new developer has come to build the stalled project at current market price, which is much higher than the earlier agreement? So is there any recourse for the home buyer to get back the money is what they ask.
You can read through the judgment of IREO 5 Rivers, the company which was resolved by me only.
Okay.
This is bench 4 of NCLT Delhi bench, where all the home buyers had the opportunity and option to get a refund along with 10% rate of interest till
Right.
CRP date, or they can opt for the property they want to buy according to a prefix price in the resolution plan. The differential, if they have paid more than that, the refund will happen. If they have paid less than that, they have to contribute it.
Right, sir. I think that judgment will be useful.
Yeah.
Another question, sir. Implementation of plan is also an important element of resolution and includes various accounting and taxation aspects like treatment of write-offs, reevaluation, and write-back of liabilities. Is there any guidance on how to treat this proposed treatment which are given by resolution applicant in the plans?
Yeah. Now this section 41 has been amended. So before that, any write back in case of working capital was to be added back as income. Now, all kind of a write backs means to the term loan as well as working capital after this budget will tantamount to the income of the CD.
Okay, okay. That will entail a tax liability, sir.
So the resolution plan is now to be very professionally designed.
Right, right.
And passed accordingly.
True, sir, true. Because I think for remission of trading liability, there was a Supreme Court judgment in Mahindra.
Yeah.
Which people
that Mahindra goes by this amendment of this budget now.
Yes, sir, yes, sir. Becomes more trickier now.
Yeah.
Yes, sir. So that's all the questions.
Yeah.
We had much more, but some got repeated and some not. Some are off topics.
Okay.
Thank you for your time, sir. We already says 10 minutes beyond timeline. Ma'am, Rita ma'am can take over now.
Yeah.
Thank you, both to the speaker and to the moderator, Krishnavindu sir and Badriji. Krishnavindu sir for making such a elaborate, detailed presentation on the subject, backed with case laws and explaining the very essential and special feature about moratorium under IBC, how different it is, what is the speciality of this particular provision under IBC. And you had very patiently answered all the questions, sir. There are still more, but
I was
lots
expecting almost 70 to 80
yes,
and,
lot of questions.
Narayanan was so polite and he bounced back only 10 to 15%, I think.
And thanks to Badriji for moderating the entire session, making it as much interactive as possible. Thanks to both of you, sir, on behalf of the Committee on Insolvency and Bankruptcy Code of India. Thanks to you, sir.
Thank you, ma'am. Thank you for having us.
you.
Thank you, sir, for your time.
Thank you.